The Department of Education is the largest creditor when it comes to collecting federal student loans. And with millions of borrowers currently right now indebted to the Department of Education, many more who are actually in default, and this could all be to no fault of their own. What we're going to do today is we're going to go over this lawsuit that the American Federation of Teachers has filed against the Department of Education. Now, mind you, when we go over this lawsuit, I'm actually going to break it down in sections because there's a lot to unpack here. If you are a federal student loan borrower, it's important to be connected to information, especially information when it comes to the harm that the Department of Education has caused to borrowers who are in the same situation. This lawsuit that we're going to go over, this actually took place. It actually was filed March 18th of 2025, but this complaint has been amended. There's a lot of things that have happened in the federal student loan world when it comes to the Department of Education blocking bars access to income general repayment plans. Also, we know with the SAVE plan, if you're someone that is in a SAVE plan, what all has been taking place with the SAVE plan, bars have been put back into interest has started accruing on student loans. Not only that, we have the introduction of the One Big Beautiful Bill Act. So there's just a lot of information that is going around out here around in regards to federal student loans. So for myself, I like to read lawsuits. I love reading the lawsuits because there's so much information in here. Not only that, like I said, you get to see exactly how borrowers have been harmed, and not only that, what laws and things of that nature are being used to bring these complaints and these lawsuits against the Department of Education. So if you are a bar that is experiencing the same things, this may be something that you can further look into if you may need to protect yourself. Okay. So we're going to go through this complaint. All the information, if you want to look at this complaint yourself, all you have to do is just take the case number that's at the top of the document, plug it into Google, and you'll be able to bring the information up as well. Also, I'm going to link all of the information down at the bottom of the video, so you'll be able to go back. Like I said, I'm gonna do this in sections because like it's a lot to unpack in this complaint, and I just want to make sure that I can thoroughly explain everything, and that way we all have an understanding of what's going on. My name is Tammy Arrington. I am the owner of Tammy A1 Consulting. Like I said, I love to read lawsuits. I am in the education space. I love educating anything in regards to federal student loans, credit, just financial literacy, and just being more aware of what's going on around us. So let's go ahead and get started. Now, this here's the actual complaint. I'm going to minimize this just for a second here. So that way I can show you, because like I said, this lawsuit actually took place on the 18th of March. So this is Court Listener. This is the website that I'm on. And you're able to bring this up. You can just go to Google, type in American Federation of Teachers, and you'll be able to find all of this information. But what it does, it gives you a play-by-play from the date that the complaint was filed, March 18, 2025, all the way down to current today. So we're going to scroll down because there's a lot has happened. Okay. Oh, I went too fast. All the way down to currently what has taken place. Okay. So this is where we're going to go to see where this complaint has been amended. And we're going to go through this step by step. Okay. All right, so if you click download PDF, that is where it's going to take you to the complaint here. And in this video, what we're going to do is we're just going to go over the preliminary statement. Basically, this is a synopsis or a quick shot of what's to come and what the complaint is all about. So we have all of our plaintiffs here in the case, the American Federation of Teachers, and also all the plaintiffs who are borrowers who have been harmed by the Department of Education and them blocking access to repayment plans, forgiveness, all of those things, okay? So we have the Department of Education here, who's the defendant. Let's keep going down. So let's just break down this preliminary statement. So what it says, the United States government, through the United States Department of Education, is the country's largest creditor of student loans. Today, there are nearly 43 million federal student loan borrowers with approximately 1.62 trillion in outstanding debt. Congress designed the federal student loan program to expand access to higher education and increase economic mobility regardless of one's financial station. To that end, when designing and modifying the federal student loan system, Congress provided clear and specific directives to the department so that millions of Americans can repay their loans without being hindered by the debt. Specifically, Congress directed to the department to offer income general repayment plans that tie a borrower's monthly payment to their income and provide debt cancellation after a prescribed period of time. Notwithstanding this clear congressional command, the department withheld IDR plans and their benefits from millions of borrowers. Although the department has nominally restored these plans, In practice, more than 1 million borrowers still do not have access to their congressionally mandated benefits. The department has not indicated when it will grant access to the program. The same is true of the department's administration of the PSLF, or Public Service Loan Forgiveness Program. Public service workers who have satisfied all requirements to have, hang on, I went too far, their loans canceled under the federal program are being deprived this right to promptly have their debt forgiven. The result, borrowers are and have been unable to access affordable monthly payment plans. Some borrowers are being and have been thrust into default on their debt, and some borrowers are being denied their right to have their loans canceled through IDR or PSLF. For those borrowers who have satisfied the statutory requirements to have their debts canceled, but whose loans the department has not canceled, they are trapped in a debt that legally they should no longer owe. This debt continues to appear on their credit reports, restricting borrowers' ability to access credit to purchase homes, cars, and other necessities, and with looming tax consequences if action is not taken swiftly. These borrowers must also make payments on a debt that should no longer exist for fear of becoming delinquent, or agree to be placed in a forbearance with no clear end date. So right here, when you look at this information as the result of the Department of Education not doing things that are congressionally mandated, what this means for borrowers who are stuck in this system. This is the financial harm that is being caused to borrowers because of the fact of either not being able to access income-driven repayment plans, not being able to have their loans discharged when they already qualify, they've met the terms of a repayment plan, or if they are being forced into a forbearance. But it says this is not occurring in a vacuum. So what we know, this is not an isolated event, okay? So this is not occurring in a vacuum for student loan borrowers. It comes in the context of the president repeatedly announcing his plans to close the Department of Education, which was created by an act of Congress. So if you've been following everything that's been happening, the current administration, their goal is to shut down the Department of Education. The Secretary of Education, her goal is to, what the president has stated, is to work herself out of a job, okay? But we know that the Department of Education was created through an act of Congress, and in order for it to be dismantled or shut down, an act of Congress would have to be done through an act of Congress. And it is on the heels of the recent equally unlawful actions to gut critical student loan protections that had until recently been provided by the Consumer Financial Protection Bureau. So also there was a gutting of staff at the CFPB. Things with this is still working through the courts, but there's lawsuits that were in play that were brought by the Consumer Financial Protection Bureau, one of which was a lawsuit against Navient, who was a huge, and at one time was one of the number one student loan servicer, federal student loans. And now they have been banned from servicing federal student loans. Of course, they are still, actively, servicing loans, not federally, but the fact that we have a lawsuit against Navient that is still, out here lingering, and borrowers have not received their redress behind the harm caused by Navient. But although the department has begun to process pending IDR applications after this case was filed, the slow rate of processing and lack of transparency with respect to whether processed applications are being correctly approved or denied do not meaningfully address the reality that borrowers are still being denied their statutory rights to affordable payment plans and to debt cancellation. As of July 31st, 2025, there are 1,386,406 pending applications. But the department's processing rate and the rate of new applications being filed results in only an average net decrease of 87,823 applicants per month. At this rate, borrowers may have to wait years to receive the benefits that Congress directed should be provided to them. Now, one thing to know about this lawsuit is that they had, in the initial complaint, requested a status report. And this is something you can actually go back and view. So that we require every month that the Department of Education provides a status on where they are in regards to income-driven repayment plans, processing of the applications. That could be in denials, approvals, also PSLF buyback, public service loan forgiveness. So you can go back and you can look at the status reports, and you'll be able to see every month the updates. Okay. All right, let's go back. Okay. All right, so we know that they're saying at this rate, as slow as they are processing these applications, borrowers may have to wait years to receive the benefits that Congress directed should be provided to them. For borrowers who have met their statutory requirements to have their debts canceled pursuant to IDR, but whose cancellation the department is withholding, also face a form of fiscal cliff. Pursuant to the American Recovery Plan Act, for loans not canceled on or before December 31st, 2025, the canceled amount will be considered taxable income for federal income tax purposes. If the department does not process their cancellation before this deadline, these borrowers will literally pay for the government's inaction. So under the American Recovery Plan Act, what under this act, there was a temporary federal tax exemption, meaning that if your student loans were discharged or forgiven, however you want to word it, prior to December 3rd or by December 3rd, December 31st, 2025, then you would not be subjected to the tax implications that comes with that particular debt being forgiven. But because we see that the Department of Education is dragging their feet, there's no staff. The staff has been cut in half and probably less than that, that they're not able to get all these applications processed or to get borrowers into the right programs or to get borrowers to that are already have satisfied the terms of their programs to get those loans discharged. And if they don't have that taking place by the 31st of December, because we see at the rate that they're processing applications, then what happens to these borrowers come January 1st, 2026, if these loans are not discharged? Because depending on what state that you in, could determine if you are going to be subjected to having to pay taxes, counting that forgiven debt as income. Okay, so that's what they're talking about here. What not only them taking their time or not getting applications processed and forgiveness processed, but what other fiscal and financial things can happen to borrowers whose loans are not canceled by the 31st of December. Now, here when we get to number 10, the department's unlawful activity is especially harmful for named plaintiffs. So we've seen who the plaintiffs were in this complaint. But when I see this, and like I said, I enjoy reading lawsuits. But when I look at the information here, and although this was filed on behalf of the plaintiffs that are working with the American Federation of Teachers, this is for borrowers in general. Because this is happening, like I said, this is not something that's just happening in vacuum. It's just not a single borrower that it's happening to. It's happening to millions of borrowers. So although, yes, this claim, it specifies who the plaintiffs are, but if you are a federal student loan borrower, this affects all of us. So we want to know exactly what the unlawful activity is if you are not aware of how you have been harmed. But like I said, as well as knowing what what they are using, what the laws they are using, what the complaint is, and so forth, so that way you can utilize that if you have to bring any type of complaint against the department yourself, or just to start becoming more familiar about everything that is going on and start recovering your documents and looking at things a little bit more closely based off this information, okay? But it says the department's unlawful activity is especially harmful for the plaintiffs, for borrowers, who are long-term borrowers and public service workers entitled to have their debts canceled through IDR and PSLF program. It goes more to talk about the plaintiffs who have satisfied their requirements, also the amount of debt that they have. But it also states named plaintiffs and the millions of borrowers who they represent are being trapped in debt. And when they say whom they represent, they're referring to the American Federation of Teachers. And many will face enormous tax liability if the department does not follow the law and cancel their loans before the 1st of January 2026. At bottom, these borrowers simply want to pay back their student loans according to the terms that Congress and their contract provide. So when they talk about the contract, that's that master promissory note that every single student loan borrower should have signed when taking out your federal student loans. You can access your master promissory note, and some people aren't able to, but the master promissory note is usually in your student aid account. So when you log into studentaid.gov and you go in your documents, you should be able to see your master promissory note there, and that is where you're going to read over those terms and conditions, okay? But so it says behalf of its members and named plaintiff bring this lawsuit, and it tells us why they are bringing this lawsuit against the Department of Education. They're bringing this lawsuit to compel the department to abide by Congress' command and provide borrowers with the ability to repay their loans through the affordable income-driven payment plans to which they are entitled to, and to cancel their debts when they have satisfied all applicable requirements for those plans and the PSLF program. So they are not asking for anything that is not legally due to them. They're asking for the department to abide by the terms, to abide by the regulations, to abide by the law that Congress has set in place. And they're asking the courts to compel them, to force them to do that, to have them to comply with the law. That is all they're asking. And this is another thing that I've always said, I don't believe that anyone takes out federal student loans with the intentions to not pay them back. Me personally, I just don't believe that. So we know that these borrowers want to pay their loans back, but they're not able to due to the fact of the departments and their I don't even know if we can call them shortcomings, because at this point these are things that they're doing on purpose, in a sense, by not allowing borrowers to access things that are congressionally entitled to them. Okay. All right, this more or less talks about the jurisdiction and venue. I'm not going to go through that. This is just more or less talking about the authority and the location. As we get down here under parties, this more or less talks about who's involved, what their duties are, who the who the AFT is. That's what the American Federation of Teachers, who they are, what their organization is about. And then two, as we continue down, because I'm not going to go through this, I'm going to skim through. You can go back and read through. They also did some stats. They did some surveys of the borrowers that they have in that they are working with. You can go back and look at that. It just more or less tells you what sector of people that they're working with are being harmed, as far as females, their race, all kind of things. But you can just click that or highlight it and hit search. You'll be able to read that. You'll be able to see that. The second page is more or less telling you about what they have done, what the American Federation of Teachers has done, what their organization has done. And then here, when we get down here to number 23, this is basically what the goal is of the complaint. The relief sought in this complaint would inure or be to the advantage or the benefit of thousands of AFT members who are actually injured by the department's violation of the statutes requiring that IDR plans be available with applications processed in a timely manner, that borrowers who have satisfied the IDR repayment plans requirements for debt cancellation have their loans canceled after 20 or 25 years, and that borrowers who work in public service and have satisfied the requirements can have their loans canceled after 10 years. Because if you qualify for PSLF, you are eligible to have your student loans discharged after 10 years of making repayments under a qualifying repayment plan. This more or less here it gives you more background on the plaintiffs, and as you see, you'll see these plaintiffs, these borrowers have been in repayment. This one over 25 years, over 25 years, 20 years. Look at the amount of student loan debt that they have. But go back and read their stories, because it applies to a lot of us. This is everyday borrowers who this is happening to, who have the same circumstances as you. But right here, I wanted to go a little bit more into number 28, because this gives you that timeline of the save forbearance. And if you are in the save plan, or you have been in the save plan and you try to switch over into another income driven repayment plan, this more or less gives you that time frame. So when you're looking at your documents, because remember, we're talking about the largest creditor in the United States, in the country. So what that means is that we have a creditor that's coming after you to collect the balance. And you want to make sure, even though that you're dealing with a student loan, that the balance is accurate, that they're able to account for every cent that they're claiming that you owe. And because we have borrowers who have been placed in forbearances involuntarily, then placed into repayment plans, all of this switching around and all of these pauses, we don't know what the coding system looks like on the back end. And we want to make sure that these servicers have properly applied payments, interest has been applied properly, forbearances have been applied properly. All of those things have taken place, and you have the right to know that. Okay. All right. So let's talk about this really quick. So we talk about the plaintiff, Rachel. And we don't need to, as far as where she lives at, but it says she has been paying over 10 years without delinquency or default while pursuing PSLF. By July 2024, she accrued 115 of the 120 necessary qualifying payments for PSLF and was on track to reach her 120th payment by November 2024. The department placed her loans, along with the loans of millions of other borrowers, into an involuntary forbearance in July 2024, during which time she was unable to accrue more credit towards PSLF, because we know when that save forbearance happened, you were not able to accrue any, that time spent in forbearance, you weren't accruing any type of credits if you were pursuing discharge under PSLF or just income driven repayment. So, all right, so she was unable to accrue more credit towards PSLF beginning in December 2024, and then again in January and April 2025. She submitted PSLF buyback application to recoup these months in forbearance for PSLF. So the Department of Education announced that if the time spent in the Save Plan forbearance, you were able to purchase those times back, because in order for your loans to be discharged under PSLF, payments have to be made under a qualifying repayment plan. because the save plan, there was a forbearance that technically was not a qualifying repayment plan because you were not able to make a payment due to the injunction against the save plan. You were not able to make any payments that would count under that plan. So that is why the PSLF buyback came into play, and you were able to submit a request to buy back those months, however long you spent in the save plan, so that way it would technically count towards credits towards PSLF. Okay. But the department has not processed her application. She also applied for IBR in January 2025 and was approved in July 2025, but she has not been able to make payments on the plan due to an error between the department and its student loan servicer. An error. And so she was placed in another forbearance. The department is therefore withholding her statutory right to cancellation through PSLF and to accrue more PSLF credit through the IBR plan. So we know right here an error and what errors can do to a student loan account, or just an error in general to anything in life if something is happening. So that's why it's important. Like I said, we got to know exactly what's been taking place, and start looking at these documents and requesting these documents. Actually, on my website, I have a whole packet where you can request information, how to request your documents from the Department of Education, from your loan servicers. Not only that, through the Freedom of Information Act, if there's things that you want to know about your school, you have the right to request all of that. Okay. And I have a document on my website that will help you do all of that. Okay. But this more or less just goes in more in about the plaintiffs, and then also who they are suing. Defendant Linda McMahon is the Secretary of Education. Plaintiffs sue Secretary McMahon in her official capacity. She is charged with the supervision and management of all decisions and actions of the United States Department of Education. And so all allegations in this complaint against the Department of Education are made against her. All right. Stay tuned for part 2. We're going to go into the background, and we're going to keep breaking this down so that way we can get through the entire lawsuit, and you'll know how to utilize this information. All right. I'll see you in the next video.